Many workers in the United States are covered by what's called a non-compete agreement. And this is a contractual agreement, one that you sign with your employer often when you start on day one, that says that you agree not to join a competitor within a certain amount of time after you leave the company and within a certain radius. And for many employees, this really benches them if they are let go from the company or if you resign. It really limits the employers that you can work for a certain amount of time. And we've seen a proliferation of these, so employers using them more and more. So not just higher level employees where it makes sense, but all the way down to, to line cooks in fast food restaurants. I mean, really, you need a non-compete to prevent these folks from leaving Chipotle and going to work for McDonald's. So the FTC just announced yesterday or finalized a rule that bans all non-compete agreements for any employees making less than $151,000 a year. And even if you make more than $151,000 a year, you have to be in what's called a policy-making role before your company can legally require a non-compete agreement. There are also some other limited exceptions. If you're selling and buying a business, a non-compete can stay in place for those reasons. And for those sorts of workers, it makes sense. You're on a policy-making role, or you're a higher level, or you're buying or selling a business. You can negotiate these terms. These are terms that you want. Many employees don't have that power to negotiate, and they're just covered by these blanket non-compete agreements, which hamstrings them from finding other work. So the FTC has outlawed non-competes for the vast majority of workers in America, allowing them to more freely go work for employers and to use their talents where they are most valued. Now, the catch is that this rule will not be fully enacted for at least 120 days, and it's already going to be challenged in court. The U.S. Chamber of Commerce and other business interests who like non-competes have said that they believe that this is illegal. There are a bunch of different reasons for that. The primary one being they are claiming that that the FTC doesn't have the actual authority to enact this rule. We'll see what happens with it. This will likely end up before the Supreme Court. I think the FTC has been very careful here in how they enacted this rule, but the conservative majority on our Supreme Court now has been sympathetic to challenges to claims that administrative bodies like the Federal Trade Communication have acted outside the bounds of their authority. So we'll see. It is possible that this rule never sees the light of day and is overturned by the Supreme Court. I think it's a coin toss. But if it goes into effect, it'll be a sea change for American workers because, again, unless you're in these limited pool of people who are exempt from it and can be covered by non-competes, you'll be free to leave your employer and go to work for whatever company that you want to. The Department of Labor yesterday just released a very powerful rule regarding the Fair Labor Standards Act, or the FLSA. FLSA is what governs overtime and minimum pay for all workers in America. And the rule increased the salary threshold over which you are assumed to be exempt. So certain workers are exempt from the overtime requirements of the Fair Labor Standards Act. So if you work over 40 hours, you're not entitled to get the time and a half pay required by the law. It's currently set at $684 a week. It's going to increase to a total of $1,128 a week, so a significant increase. And it's going to happen in two stages. The first stage is going to jump up to $844 a week. So if you make more than that, you will be assumed to be exempt from the Fair Labor Standards Act. Now, you may or may not be, but if you're above that, if you're below that salary, it'll be assumed that you are not exempt, or you are entitled to time and a half for overtime. So the first jump will take place on July 1. The final jump will take place in January of 2025 when it jumps up to the full 1,128. Now, the reason that this is so important is, first, it's going to give about $1.5 billion in people's pockets as a result of this change. The second is that employers are required to know about these laws and to enact them. There's no "I didn't know about it" excuse that gets an employer out of the Fair Labor Standards Act. So I think what we're going to see is a lot of employers get caught by this. And as an employee, you should be watching for it, because we would hope that employers would understand this and would enact the changes, but many of them, I fear, will not. And if they don't, then you will have a claim under the Fair Labor Standards Act, which is a very strong claim in the sense that you can get back pay, you can get your attorney's fees paid for, and in certain circumstances, you can get 2 times the underlying damages if you can show that the violation, that your employer willfully did not pay you the money that you're owed. So a very, very powerful step that should support a lot of workers in the United States.